And welcome to a quick update on the insolvency aspects that relate to directors when dealing with very difficult circumstances. Let me first introduce you to Ambuja Bose. She leads the Insolvency, Recovery and Restructuring team at VWV Solicitors.
Let me introduce you to Ian Robert, who heads up the Insolvency and Restructuring team at Moore Kingston Smith. In a situation of financial distress, it's very important for directors to be conscious of their fiduciary duties. If directors have access to loans or funding, is there anything that they should be doing or not doing with those loans to make sure that they don't breach those fiduciary duties?
Yes, it's very important to understand what they can't do with these loans. I think a lot of the time directors are used to taking a certain amount of drawings out of the business, and therefore by easy money and getting a bounce back loan into the business, they can then draw that money out and keep their drawings at the levels they were before. Now that's furthering their own pockets, but not actually helping the company. So that would not be an appropriate use of a bounce back loan. Similarly, because bounce back loans are not subject to personal guarantees, it's quite possible that a director might think it perfectly reasonable to bring the bounce back loan into the company and then use that to pay other creditors where they have got personal guarantees. And that would be considered as a preference, and the directors could potentially be personally liable for paying back those loans themselves. So when a bounce back loan is taken, it should be taken to be used within the business, therefore to pay employees under normal operating capital. And obviously paying employees, if they've got employees on furlough, they don't need to use it for that. But there will be other expenses that are operating capital, i.e. their day-to-day activity of the company. That's a perfectly valid use for a loan, and that should be evidenced by a cash flow.
If business is going through a difficult time and the directors might find that there's a new innovative product that might help their business survive the uncertain times, or a new service division, could they use funding to help them with that?
Yes, absolutely. I think, that's a perfectly valid reason. They must evidence it to explain why they believe that was in the right interest of creditors and in the right interest of the business. I think there's a large, many different variances for what they can use that money for. But the two things they shouldn't use it for is to pay other creditors where they personally guaranteed the debt, because there's a clear inference as to why they're paying that debt and not other debts, and to transfer the money to themselves so they can build a swimming pool in their back garden, or just to fund their lifestyle. Clearly that's not an acceptable use of that money.
I'd absolutely agree. When I come across cases where there's action taken against directors for misuse of company funds or for other misfeasant actions, there are certain things where they clearly put their own interests at heart rather than the company's interests and the company's creditors' interests. But there's also a huge grey area as well. I'd always say that directors should take professional advice as soon as possible if there's any doubt as to what they could or should be doing. What are your views on that?
I think that's the first do of any director. If you've got financial difficulty, take advice. I think everyone's got an accountant or a friendly insolvency practitioner or a friendly lawyer that they can get hold of. And we all are quite happy to speak openly over the phone for free in the initial instance, and start guiding you as to what your next step should be. I think it's very important that you evidence what you do and why you did it, but probably even more important to seek advice first, and then following that advice, evidence what you've done and why you're doing it.
Indeed, and from my point of view, risk mitigation is really important, because there will unfortunately be circumstances where insolvency can't be avoided. But if directors can show that they acted responsibly and reasonably and mitigated any risk of loss or minimised the losses, they could see themselves in good light and could successfully defend any claims or actions which might be brought against them.
I completely agree. I think we've been talking about misfeasance here and claims against directors for negligent actions, or possibly even more than negligent if they're just drawing money off the government or for bounce back loan and then putting it into their own pockets. But actually what I want to now focus on is the difference between misfeasance and wrongful trading. And I don't know, Ambuja, if you want to just talk about wrongful trading and how the suspension has perhaps helped directors or not helped them.
Absolutely. So misfeasance, which is what we've been talking about so far, is where there's a breach by directors of their fiduciary duties, which are set out in statute within the Companies Act. Wrongful trading relates to a situation where the directors of a business continue or allow that business to continue trading once it's reached the point of insolvency. Generally, and in usual circumstances, as soon as directors realise that insolvency is inevitable, they should cease trading straight away.
Or ought to have realised, I think.
Or ought to have realised that insolvency is inevitable. They should cease trading straight away. The government have tried to give a little bit of support and help to directors who would otherwise be in an insolvent situation by suspending the liability that could be placed on directors for trading whilst insolvent due to the current pandemic. At this point in time, the pandemic means that many businesses, but particularly those in the hospitality sectors, in the leisure sector, in the retail sector, hoteliers, for example, a lot of them are technically insolvent because they aren't able to pay their debts as they fall due, or they're insolvent on a balance sheet basis. Ordinarily, all of those companies would have to cease trading immediately to make sure that they don't fall foul of wrongful trading provisions. But the government have given support, and they have agreed that at present no action will be taken against a director for allowing a business that is otherwise insolvent to continue to trade. Whilst that's how the law sits, there are some really key legal points to take away from that if you're a director of a business. Whilst you're allowed to have your company to continue to trade, you must make sure in that trade you're continuing to act in accordance with your statutory fiduciary duties. So whilst trading, you have to act responsibly, you have to act reasonably, you have to have the interests of the company's creditors at heart. You shouldn't be acting in any situation where your personal interests or personal benefits are put before the creditor's interests, and you shouldn't be putting yourself in any situation where a conflict of interest arises. And so whilst there's a little bit of leeway which allows directors to explore options whilst they continue to trade in an insolvency situation, there are another huge host of issues that they must take into account to make sure that they don't fall foul of the misfeasance provisions.
I think to summarise here, I think the government had very good intention when it suspended the wrongful trading rules to help directors to continue to trade. But it's to some extent a little bit of a red herring, because it doesn't give directors a get out of jail free card to just go about their business without care or planning, because they will then be guilty of breaching their fiduciary duty. So, my concern is that the suspension of wrongful trading is possibly sending out a wrong signal. So from a practical point of view, I think directors can't look at that and think, okay, they can do what they like, because that issue isn't going to hit them now. And by the way, it's only suspended to the 31st of March. So, that goes again, unless it's extended at the beginning of April. I think that's all we wanted to say on that subject. It's quite a complex subject. And as I say, you need to take financial advice from a lawyer, from an insolvency practitioner, from your accountant, if you are faced with those issues and those decisions to be made.
So absolutely, if you have any questions, do feel free to get in touch with either Ian or myself.